Welcome back. Judge Gordon Lowe is the presiding judge of the First District Court serving elders in the rich countries in the United States of America. After graduating from Arizona State University of Law in 1973, he joined the law firm of Hilliard and Grinnell as an associate and later became a partner. Judge Lowe is a member of the Supreme Court Advisory Committee on Evidence, the Family Court, and is serving his second term on the Board of District Court Judges, where he served as chair for 1 year. Judge Lowe is in Namibia to do work with President Damasev's office, doing consultations and workshops on alternative dispute resolution, and now joins me in the studio. Good morning and welcome, not just to the studio, but to Namibia.
Good morning and thank you.
Yeah, how's your first visit been?
Wonderful.
Yeah?
Everybody's been very hospitable. We've been treated very kindly, and we've enjoyed it very much.
Okay. Judge, I think we're here to talk about a very serious issue, which is alternative dispute resolutions. What is an alternative dispute resolution?
Alternative dispute resolution is attempting to resolve disputes and claims outside of the mainstream litigation judicial system, so that we remove some of the pressure and load on the judicial system and resolve disputes outside the system, hopefully in a more timely fashion, maybe less expensively, and more satisfaction can be obtained that way through a non-judicial resolution.
I mean, the biggest criticism for Namibian judicial system has been the court role, and how sometimes, cases go on for an extended period of time. Is this exactly what this alternative dispute resolution is attempted to address?
It's part of it, and it's not just Namibia. It's everywhere, especially in the English Commonwealth legal systems, which we share in the U.S., for example, with Namibia. It is part of a case management attempt. Courts in the past number of years have been involved in case management reform, improving case management, and sort of the capstone of that is finding alternative ways to resolve disputes. Alternative dispute resolution has been around for a long time in different forms. Arbitration, for example, is taking the lawsuit out of the courtroom, having it resolved and decided elsewhere. Mediation is another function of alternative dispute resolution outside of the courtroom, and it's an attempt to resolve disputes without the time, the risk, the costs associated with the traditional judicial litigation system.
But isn't there a risk at some level taking those judgments outside the courts? Would there still be legitimacy? Would there be legitimacy in the judicial process of Namibia?
No, that's not really a concern, because certainly there's always a place for the courts. The courts are necessary. Everything we do in the law is done against a backdrop of trial. What will happen if a case goes to trial? And we've developed here and elsewhere in the English common law system thousands and thousands, millions of case law precedents that we can always refer to. This is taking cases out of the court that need not be tried. Every dispute should not be tried. There's no need to try every claim, every dispute, every issue. Most of them have been decided before, and we can draw from that experience and apply it in cases today. The courts just simply get overwhelmed with a number of claims that are brought, and there's no need to have them all disputed there or resolved there. In fact, the real theory behind mediation is that courts do not resolve disputes. Never. They simply end them.
Yes.
And people live with the end.
Yes.
Which is fine. It also establishes law and the law of the case. But in mediation, we can help resolve the disputes rather than simply end them, and help parties find resolution to a claim or a dispute without the cost and the time and the risk associated with the traditional judicial system.
But would the function of mediation still then fall under the jurisdiction of the courts?
Exactly. As a matter of fact, under the new rules which have been promulgated and implemented just recently here in Namibia, the program is, and the protocol and procedure is, that when two parties enter into a mediation and find resolution and sign off on it, it's final. And there's no judicial review. The courts honor that agreement and that resolution.
But who are these mediators? Is it people who are independent? Other law, for instance, when you go to arbitration, sometimes you can identify an independent arbitrator or mediator. Who is going to be mediating this?
Well, you raise an excellent point. In arbitration, you sort of rent a judge, if you will. You create somebody to be the judge, and that decision is final, perhaps subject to judicial review, depending on the procedure and the protocol. In mediation, a mediator And under your rules, and they're not entirely dissimilar to a lot of other rules, a mediator will be qualified and certified, if you will, by the courts to conduct mediation. The mediator is independent, neutral, doesn't have a dog in the fight, if you will, has judicial independence, and helps the parties find a resolution and conducts the discussions and the mediation sessions in a manner which hopefully will result in a resolution. Most parties can find resolution to their disputes without judicial intervention. There's nothing, I need to be cautious about this. I've been a judge for a long time. There's nothing special about a judge being able to decide a case or a dispute or resolution any better than parties can. They know the facts, they know the issues, they know themselves, and with a little bit of leadership and guidance from a skilled mediator, they can generally find resolution. Most cases can be resolved.
Okay, but what are the type of issues that we're trying to move towards these alternative dispute resolutions? Are we talking about, you know, traffic fines or drunken driving cases? What are the type of things that we're trying to move into kind of the domain or the mandate of these alternative dispute resolutions?
Great question, and the simple answer is civil cases, not criminal cases as you just mentioned. We're talking about civil disputes that can be resolved. The time will come likely when criminal cases may also be subject to mediation, but that's a long ways off in every jurisdiction. I know of no jurisdictions which are where mediation is used in the criminal field, but in the civil field, all cases, primarily, and most other countries who have adopted this mediation method, and Namibia under its current rules and the new rules, domestic cases, divorce cases, for example, they're prime areas for mediation because they need to get resolved immediately, as quickly as possible, with as little acrimony and dispute as possible, and they're very good areas for mediation. A lot of jurisdictions, including Namibia, emphasizes that as an area where we want to refocus, but every other area of civil law as well, contract, property law, borderline disputes, for example.
But what percentage do these civil cases constitute of the total amount of court cases?
I don't know what the percentage is in Namibia, but ordinarily about 50%.
About 50%, so we're actually looking at a tremendous, significant change that could happen.
Considerable.
As an estate. But let's get back to your little personal experience. How has it been working, you know, with your experience in America within the Namibian judicial system?
Let me back a little bit further in that. The U.S. has not been the prime mover in this. The U.K. has. The U.S. is catching up, and other countries, India, Australia, Canada, other large British Commonwealth countries with Commonwealth law are catching up. The U.S. has become prevalent. I'm not sure of how it compares with the U.K., but it's very prevalent, where now in many states, in fact the jurisdiction where I'm from, every civil case has to go to mediation by court order before it can come into the trial system. But it's developing to the point where cases now are taken into mediation by counsel before a case is ever filed in court. They see the opportunity to resolve a dispute without getting into the court system at all. And it has a very salient effect on the caseload. This is a caseload management tool, and it's sort of the capstone of effective and modern case management, where it's reducing the number of cases to be tried significantly. Even though case filings have risen in every jurisdiction, the number of trials has decreased, largely as a result of mediation efforts. And so it's helping a great deal, and mediation can be very successful. The percentage of cases resolved through mediation is significant. Most cases are resolved anyway before trial. Nowadays, and I'm not sure the numbers in Namibia, but worldwide, less than 2% of cases filed are actually tried. Well, the trouble is they're resolved at the courthouse steps the night before trial. They ought to be resolved way earlier, years earlier, and mediation facilitates that.
Okay. Any final remarks in terms of what needs to be done and maybe promoting the ideas of alternative dispute resolutions?
Well, just that I'm thrilled to be here. The courts have been very receptive. I've appreciated the invitation by the Judge President, Namibian, to be here to assist. And there apparently is a great deal of enthusiasm, both in the courts and in the bar, in implementing the new rules of mediation.
Well, Judge Lowe, there's definitely been a lot of criticism with regards to these court cases, so we're finally really happy that something is being done, and it sounds like it will have a significant impact in terms of just how the judicial system works in Namibia. Congratulations, and we look forward to the outcome of your stay and your work.
Thank you very much.
Thanks for joining us in the studio.
Good to be here.
That was visiting Judge Gordon Lowe, who's working with President Damaset on the changing of the Namibian court systems by introducing alternative dispute resolutions. We'll be back with more after the break.